go live in 5, 4, 3, 2, 1.
Oh, yay, oh, yay, oh, yay. This Honorable Court of Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Thank you, Mr. Hibner. And on behalf of Judge Bennett and Judge McBrayer, we welcome counsel to this oral argument, which is being live streamed so that we may fulfill our obligations to keep our courts open for the public viewing. We will conduct the hearing in the same manner as if we were all in the courtroom together, and the appellant and appellee each have 15 minutes to argue. And I understand General Kleinfelter has elected to not argue unless the court has questions. Is that correct, General? Very good. Okay, thank you. And then, and I believe the appellant has reserved some time for rebuttal. So
Your Honor.
There being no announcements, Mr. Hibner, please call the case.
Trevor Seth Adamson versus Sarah E. Grove et al.
All right, you have the floor.
May it please the court. My name is Kent Jones in Cleveland, and I represent Trevor Adamson. The first issue, there are a lot of issues in this case, but the first issue is how did the case get dismissed with prejudice if it was non-suited without prejudice? The counterclaim or the Anti-SLAPP Act was not pleaded prior to the service of plaintiff's motion to dismiss. The date of the counterclaim was October 1, 2020. Plaintiff appellant's motion was filed on August 20, 2020. Second, the defamation action is the central component of this matter. The action was not about defendant's free speech. There was a false flyer created. My client did not know anything about it, but he was blamed for it. And they tried to shut down his business because he did not invite any people in the Black Lives Matter movement to whatever the flyer said, but he didn't create the flyer. Third, Your Honor, the Anti-SLAPP Act is unconstitutional because it denies the right to a jury trial. There have been 2 cases that decided that. Washington
was that issue raised below?
Mr. Adamson did raise the constitutionality of the SLAPP Act. He said he even inserted an article on the constitutionality of it. So it's been raised at both the trial court and the appellate court.
He inserted an article, but did he expressly raised the constitutionality?
I believe in reading it that he clearly did, Your Honor. The constitutionality.
Did he assert it in a pleading?
I'm sorry, sir.
Did he assert the issue in a pleading, meaning the complaint or an answer or counter complaint?
Yes, sir. It was the way the Anti-SLAPP Act works, as you know, is he had the opportunity to present sworn affidavits. And
no, it's a yes or no answer. Did your client assert in the complaint, the answer, or a counter complaint a challenge to the constitutionality of the act?
I don't know if you consider the sworn affidavits a counter complaint. I would. And so I would say yes.
I would not. But,
okay.
Okay.
Yes, Your Honor.
Okay.
As far as the plaintiff.
Excuse me, I have a question. This is 3 consolidated cases, is it not?
Yes, Your Honor.
The notice of appeal only put one of the case numbers on, didn't it?
That's true, Your Honor.
Well, then, do we have jurisdiction over this case?
The trial court cited the final order that we appealed under the case number that we used. And secondly, as you type in a fill-in notice of appeal, it disappears and you can't get all case numbers in there. So we went with the last one because it was our intention or concern that the entire final order was consolidated into that case number.
But isn't there a case, what is it, Rainbow Ridge Resort, that says you have to list all of them?
It was a technical difficulty, Your Honor. I did not know how to do all of them so that they could be seen in the fill-in notice of appeal that I was required to file.
Did you call
Was
the
that
clerk's
technic-
office and ask about it?
No, I didn't, Your Honor. I did raise it several times, but I did not call the clerk.
Okay.
As far as plaintiff proceeding pro se, I don't think he was treated fairly as a pro se litigant. When plaintiff, his previous attorney withdrew, he tried to find an attorney, but he could not. Now, we clearly understand that under Tennessee law, he is held to procedural and substantive standards. However, there is leeway given in his brief writing, and we think he clearly cited the unconstitutionality of the Anti-SLAPP Act at the trial level and the appellate level if you give him some leeway in his brief writing. The appellees, I don't think clearly addressed the case as a whole, which was the falsity of the comments by the appellees. The critical component of the defamation case is that appellees' statements were false. They had nothing to do with free speech or the right of association. Another issue, which was a bit irritating, is the proposed orders that were signed by the judge were never circulated to us. I never saw him or had a chance to do a proposed order. In fact, I had an agreement with counsel to hear his motion to compel and my motion to stay on March 8, 2021. And he went ahead and filed a proposed order that I didn't see, and it was granted, and that's why we're here. There was an allegation.
Are you
I'm
saying
sorry.
that the council did not serve a copy of the proposed order upon you by mail or email?
I never saw one, Your Honor. But I found out that they were granted shortly after.
All right, thank you.
And all the orders were drafted by opposing counsel and signed off on clearly. As far as the allegation that the sanction was arbitrary under Tennessee law, there was no cap on what the sanction could be. There was no formula to determine what the $24,000 sanction would be. And in fact, if you read the pleadings, what happened was opposing counsel said, well, I believe it was 3 to 5% of the demand, which was $800,000. My client had nothing to do with the demand. That was his previous counsel. And he had no knowledge that he was going to be hit with the $24,000 sanction at all. And under the Tennessee law, which cites the U.S. Constitution through the 14th Amendment, the plaintiff needs to have notice of what the sanctions are going to be when he gets into a defamation case like this.
Did you say your client had nothing to do with the amount of the demand he sought in the pleadings?
He had no idea what to demand. All he did was go along with what his counsel did.
But it was his attorney who prepared that document on your client's behalf.
It was his attorney that would do it. Yes,
All
sir. There was an allegation under the SLAPP Act that my client was a congressional candidate. He was not. He did mention on social media that he thought about running for Congress, but he never paid the $5,000 or satisfied any of the requirements. So you can't treat him as a public figure. You can only treat him as what he was, which was a political organizer. And on the issue of attorney's fees, we understand that Mr. Horwitz respectfully said that he was charging each of his clients $5,000, but we really needed an affidavit of attorney's fees to show that those fees were paid. And so we think it was grossly arbitrary under both Tennessee law and the United States law, the sanction itself of $24,000. And there was no way to do anything about it. I mean, he could have said $5 million, and there's nothing in the act to stop that. In the Washington Act, where the case was declared unconstitutional, they had a definite figure. It was $10,000. So essentially, what we're saying is two things. The defamation action was pled by plaintiff in his sworn affidavit. He was pro se. He did a very good job of it. He cited what he needed to cite to get a prima facie case. And additionally, and I hate to beat the dead horse on this subject, the clear and convincing standard did not exist. So there was no way to take away his constitutional right to make a defamation action. It was a prima facie standard. And under Tennessee law, you have to have clear and convincing evidence to overcome somebody's jury trial right.
All right, anything further, Mr. Jones?
Not at this point, Your Honor.
All right, thank you. We'll hear from you on rebuttal. Mr. Horowitz.
Morning, Your Honors. Daniel Horowitz, the Nashville Bar, on behalf of the appellees in this matter. Your Honors, given the vast number of issues that the appellant has purported to raise in this appeal, I want to focus my time on just a few matters that I submit are case dispositive. The first case dispositive issue is one of appellate subject matter jurisdiction. In particular, none of the issues that the appellant has raised in this appeal, not a single one, arises out of the case that he appealed. The case that the appellant appealed has a different case number, and it has a different style. And as this court has held repeatedly, quote, an appeal of an order in one consolidated case does not constitute an appeal of the separate but consolidated case. That's from Northgate Limited Liability Company versus Amateur, a case from July 2019, which quotes Rainbow Ridge Resort LLC versus Branch Banking and Trust Company. The site on that is 525 Southwest 3rd, 252, and the pin site is 259. As a result, case number 83CC1-2020-CV-616, which is the trial court case that the appellant apparently intended to appeal, is not actually before this court. And that defect of subject matter jurisdiction is non-waivable. As a result, this appeal must be dismissed for lack of appellate subject matter jurisdiction, and it is res judicata as a consequence of the circuit court's final and unappealed order in consolidated case number 616. Significantly, as you heard today, the appellant does not dispute that his notice of appeal failed to reflect an appeal of case 616. Instead, he claimed initially that the clerk's e-filing system was to blame for the defect, but after the appellees demonstrated that the e-filing system clearly was not to blame, the appellant has changed his explanation and represented in his reply brief and here today that case number 906 was, quote, all we could fit into the fill-in notice of appeal. Your Honors, this claim is false. I encourage Your Honors to review the actual notice of appeal that the appellant filed in this case, which his counsel signed and dated by hand. There is plenty of room to, quote, fit the actual case number that the appellant apparently intended to appeal. And by failing to appeal that case, the appellant has failed to bring the trial court's order within this court's subject matter jurisdiction. This appeal must be dismissed in its entirety as a consequence. Moving on to other case dispositive issues, in the event that this court adjudicates the merits of the appellant's claims as the appellant requests, I also want to emphasize the issues that he has not raised in this appeal. To begin, the appellant asserted a wide variety of speech-based tort claims down below, all of which were dismissed with prejudice. In this appeal, though, he only raises claims of error regarding his defamation claim. Thus, the trial court's order dismissing the plaintiff's other claims with prejudice cannot be disturbed because he does not raise any claim of error regarding them. Further, regarding the plaintiff's defamation claim, the plaintiff has failed to appeal the trial court's adverse and dispositive ruling that the defendants established valid defenses to that claim under Tennessee Code Annotated Section 20-17-105C. That provision states that the court shall dismiss the legal action if the petitioning party establishes a valid defense to the claims in the legal action. The trial court held that the defendants did establish a valid defense, several of them, in fact, and the plaintiff has not appealed that adverse dispositive ruling either. As this court explained in Lovelace versus Baptist Memorial Hospital, though, this is a case from January 2016, generally, where a trial court provides more than one basis for its ruling, the appellant must appeal all the alternative grounds for the ruling. Plaintiff did not do so here, and as a result, even if this appeal is not dismissed for lack of subject matter jurisdiction, the trial court's merits ruling should not be disturbed. Last, as to the trial court's order on the defendant's claim for fees and sanctions, Your Honors, these were fact-based rulings that are subject to review for abuse of discretion. The appellant, however, has failed to file either a transcript or statement of the party's hearing on the matter, and as this court held in Re MLD 182 Southwest 3rd 890, in the absence of a transcript or statement of the evidence, we conclusively presume that the findings of fact made by the trial court are supported by the evidence and are correct. Accordingly, these rulings, both of which are supported by the record and do not evidence any abuse of discretion, should be affirmed too. With respect to the claims that were just addressed in the appellant's opening argument, the issue that he argued regarding the timing of the non-suit is not in his statement of the issues that he filed either in this court or in the trial court for purposes of identifying what was going to be necessary to this appeal for the record. The defendants down below raised two grounds for post-non-suit subject matter jurisdiction, the statutory exception to Rule 41 and the vested rights exception. The defendants prevailed on both claims, so the question of jurisdiction was actually litigated, and the plaintiff did not raise any issue regarding the timing of the non-suit in his statement of the issues or in his opening brief. As to the appellant's claim that the defendant's briefing here fails to address falsity, it was under the anti-SLAPP statute, the Tennessee Public Participation Act, it was the plaintiff's burden to come forward with evidence, and the problem here is that he did not do so. Regarding the proposed order, respectfully, Your Honor, the record makes clear that counsel received and responded to the email in which he was served with that order. But more importantly, none of the issues he raises in this appeal arise out of the order that he claims not to have received. It's factually false, and it's also irrelevant to this appeal. Last, I heard counsel say that my client had nothing to do with this demand in his complaint. Your Honor, it's his complaint. He even signed it, and his attorney prepared it. It is perfectly appropriate to hold him responsible for the ridiculous $800,000 demand that he made for speech-based tort claims while he was sporting a campaign website and had filed to run for Congress with the FEC. He was a congressional candidate. His opening brief reflects that he was holding himself out as a congressional candidate, and then in reply, he decides that he is not. Your Honor, it's very difficult to respond to claims that are so clearly belied by the record, which makes portions of this argument difficult. Based on my notes, that concludes my presentation. I rely on the briefing for the balance of the issues presented for review, unless this court has any questions, which I'm happy to answer.
Well, just to be clear, it is your contention that every issue that has been raised on appeal falls under one of the case numbers that was not listed on the notice of appeal.
That's correct, Your Honor.
Okay.
Any other questions from the panel? Hearing none, thank you, Mr. Horowitz, and we'll hear rebuttal from Mr. Jones.
First, Your Honor, on the Rule 41.01 issue, it's clear that we briefed it. It's clear that the non-suit, the counterclaim, which would be the Anti-SLAPP Act, was not filed during the pendency of the, or before the non-suit that my client filed. As far as the Supreme Court law on punitive damages, even if my client saw what she drafted, the $800,000 demand, he had no idea what that meant. And it put him in no position to understand what type of penalty he was going to suffer. When he became pro se, he did file 2 sworn affidavits. He did the best that he could as a pro se plaintiff. It was sad that she withdrew and he couldn't find an attorney. But furthermore, on the issue of the 3 case numbers, the reason that we chose the 3rd one, I think, has been substantiated by the trial court, because in the technical record, the final order, which was what was appealed, falls underneath the number that we cited. Clearly, the trial court, keeping track of it, put it under that number. So it's false that we didn't plead the right case number. Again, I would like to stress that in all of the materials that I've read and the multiple briefing that we've done in this case, we really haven't seen an argument as to why what the appellees did, which was to make up an issue that my client did not do, and then accuse him of derogatory things such as being sexist, abusive, racist. And he had no idea that that flyer was created, and he had nothing to do with it. And there has been no notice of concern by the Black Lives Matter group in this case or against my client. It's just the 3 people that are cited as defendants that are against him for, I assume, some sort of political ideology that they did not agree with him on. But what they did was false, and that leaves him the right to the defamation in a jury trial and the ability to obtain discovery under the Tennessee Rules of Civil Procedure. Defendant's counsel says that the judge had the right to decide the facts. Well, that's what goes against the common law that says a jury is the appropriate person to decide the facts in the case, but it leaves it up to the judge, and it also leaves it up to the judge not to allow discovery, which he did not.
Anything further, Mr. Jones?
No, Your Honor.
All right, thank you. And Mr. Horowitz for your oral arguments, and General Kleinfelter, thank you for being present, and we'll entertain your views by reading your briefs. We'll take this matter under advisement. Mr. Hibner.
Thank you.
This honorable court is now in recess until 11 a.m.
Thank you, and counsel, you're free to exit the meeting.
Thank you, Your Honor.